Terrific. Welcome, everybody. Let's see here. I'm going to share my screen. Here we are. Leasing land, legal and practical tips for success. I am Rachel Armstrong. I had the pleasure of being in the Zoom room with some of y'all yesterday, and I'm glad to be back here with you. So some of you already know this introduction, but hey, we've got some new faces, so I'm going to go through it again. My name is Rachel. I am joining you from northern Minnesota. This is where my family farmed outside of town, going way back. Actual photo of said ancestors there, farming on land cut over because this was logging territory back in the day. And before that, the land was stewarded by the Fond du Lac tribe of Ojibwe before the land was given to families such as my own. My history is all in farm and food system development. It's everything that I've done from working directly on farms for farmers, largely vegetable producers, and then transitioning into nonprofit advocacy and support work. I ran farm to restaurant programs. I worked with CSA coalitions. I worked for food buyers who were moving local food. And through all that work, I realized, gosh, if there's something I think we need, it might be some legal education. I had questions, my colleagues had questions, and we didn't have anywhere to go for answers about the basic legal parameters of what we were doing. Sure, we could pay an attorney like anybody can, but we didn't have that money, and we didn't know who would really be in a good position to help us anyways. So that was the inspiration for me to go to law school and figure out how we could solve this need. That's a nice picture of the foothills outside of Denver. I went to the University of Denver Law School, and in my bus drive from the trailer where I rented a trailer home to law school every day, I would stare up at the mountains and think, how am I going to do this? What exactly is the plan for starting this organization? Thank goodness it worked out. We've been around since 2012. I'm the executive director. Nowadays, I'm back home in northern Minnesota. We serve farmers and ranchers nationwide from this home base. Those are my three kiddos who keep me very busy. I have 4-year-old twins and a 5-year-old. So we know busy in this house. It's not just me. I am joined. Our staff is 5, and we are located all around the country, all remote. So that's me, but I'd love to know a little bit more about yourself. If you could type into the chat box a few things, this would help us get to know each other a little better today. Can you type in there your name, if you have an affiliation, like farmer, an organization that you represent? And I would love to know what you're an expert in. I'm using my same area of expertise as yesterday. So, you know some of the technical things about me, but if I had to define an expertise, I would say I'm an expert in canning large volumes of applesauce each year in as little time as possible. I love putting food away, but I don't like spending time on it, and I don't like messing up my kitchen. So I've developed some really focused techniques for canning. What I aim for about 10 gallons of applesauce a year because children, they love it. So do go over to that chat box and if you can and have the time, type in there in what you are an expert. And then in a few minutes, I'm going to go see if there's anything in the chat box and we'll do a little sharing. While we give you a chance to do that, I'm going to tell you a little bit more about Farm Commons. Here's our mission. We empower farmers and ranchers to understand and solve their business law issues within an ecosystem of support. So a couple of key things going on there is we really do emphasize farm business law. So we're not so much about litigation, lawsuits, not so much about more of your high profile things like, raw milk or GMOs or things like that. We're talking everyday business issues like leasing or yesterday's business structures. An ecosystem of support, that's there to say, well, we understand that farmers and ranchers can't do everything themselves. They need service providers who can also understand and assist them in resolving their issues. Those service providers include attorneys. So we also work with attorneys to help them understand what are the needs of farmers and ranchers and how can they provide them? What we do all day is exactly this: create and deliver farm law education workshops and lots of materials. But getting at the solution more deeply, we train farmers to lead solutions in their own communities. We have a few different programs, some of which we had to put on hold during the pandemic, but that are coming back around again, to help farmers more deeply recognize their own leadership on these issues and to give them a platform to bring that to their peers. So that's all about Farm Commons. Join us. We have a membership program, and that's how we help farmers and ranchers go through our Discovering Resilience workshop, which is the 10 basics that every farmer or rancher needs to know to build a resilient operation. You can also ask questions on our Q&A platform, access our guides, our templates. We got 100 plus at farmcommons.org. Farm law education can seem boring and kind of horrible. Oh my goodness, rules. Sometimes it is, but before you start feeling too bad, I want to say, look, there's a light at the end of this tunnel. By doing this, by being here, by learning about the legal mechanics around leases, you're doing something great. What you're doing can reduce risk, build a stronger community for yourself and others, and it can even create joy. That's kind of a hard sell, right? I mean, this is 90 minutes on leasing. Where's the joy? But we will get there. And I am confident that by our time together, you're going to feel a little bit of that promise of what is possible when you delve into this material. Problem, though, is that the possibility of experiencing joy is not a strong human motivator. The research shows we are less motivated by the opportunity for something great as avoiding the risk of something horrible. So I think I would be negligent if I didn't try to scare you right now, try to scare you to convince you to pay close attention. So here we go. 51% of farmers are vulnerable to losing their access to leased land within the next year. So this is nationwide. This is based on our research surveying many farmers over time. 51% of them do not have what they need to secure their access to that land. The good news is that we can fix this. These are problems that are fixable in the short term. And the other good news is that's not necessarily in knowing more law. Sure, we're going to go through some laws today, but I'm also going to show you how the solution to many legal vulnerabilities, including around leasing and land access, is in stronger relationships. So we'll show you why, we'll show you how to build those strong relationships, and we're going to be off and going. And then we can be happy like a piggy next to a water trough. Sounds good. But again, let's get back to that fear, because that fear is a real motivator, isn't it? So that's where I'm going to go next. Feel free to keep that chat box going with who you are, where you're from, and what you're an expert in. Leah, I love your area of expertise, scrounging a reasonable meal out of random food items that happen to be in my fridge. Such an awesome skill. Sometimes I wonder how long I could go if I couldn't buy any more food. It's probably a really long time if I, search long enough in the cupboards and the freezer. All right, we're going to get into it. Let me tell you about Farmer Sam. Okay, Farmer Sam was growing sea garlic as a way to raise capital for his own operation in the future. This most recent fall, and this was several years ago, so that most recent fall, he had put $30,000 worth of sea garlic into the ground. He was excited. He was going to harvest it the next summer, as one does with garlic, and that was going to be his down payment on the land he had his eye on. But then on November 30th, Farmer Sam gets a call from his landlord. His landlord is in the process of selling the property and wanted to let Sam know that the lease would not be renewed for the coming season. So Sam panics, understandably, and he's very worried. Was he going to be left without any access to the land or to the very valuable crop that he had planted a month ago? So Farmer Sam called Farm Commons. He needed answers, and he assumed that the law would define what was fair in this situation. So he's calling us to say, what does the law say? What's fair? But reality, of course, is a little bit different. The first question that I had for Sam was, okay, tell me what you and the landlord agreed to as to when and how your lease would renew from year to year. What do you think Sam said? If you're thinking to your mind, Sam is going to say, the landowner and I didn't agree to anything. We didn't talk about it. Well, you're right. That is the situation with Sam and most farmers. They don't talk about renewal. It just keeps happening, or it doesn't happen. The issue doesn't come up for a direct conversation. This is a bummer. In this case and in other states, what that means is if Sam doesn't have a plan, the state has one for him. The state does have a set of default laws, we could call them, that are there to step in when two people don't figure out what they want for themselves. That is surprising to many folks. They are surprised to learn that the first source of authority for what is fair in a situation like this is not the statutes and the regulations. It is the agreement of the farmer and landowner. The law wants to honor, first and foremost, the agreement of those two parties, especially in this context where this is a commercial relationship. It's not exactly the same when it is a residential relationship, but this is commercial. This is business. Sam is a business person, and so is the landlord. And that's what the law wants to honor, the agreement of business owners. State law only kicks in when they don't come up with what they want for themselves. Now that's bad news for Sam. As you can imagine, the default state laws are not written for garlic producers. Garlic is an odd crop. So he did not have a lot of ground to stand on in terms of keeping access to his garlic crop. We can explore state laws in a little bit, but I'm not ready to go there yet. This is a dark story for Sam, but I want to show you the silver lining. Farmers and ranchers have power. Farmers and ranchers can create agreements that suit their operations and see those agreements protected in court. Those agreements are the law. If folks take the time to create solutions that work for their business, then the law is there to back them up. So this is my lead story because it illustrates a theme that's going to come up again and again. If you don't have a plan, the state has one for you, but you might not like it. Your best chance for resilience is coming up with your own agreement. So legally, the legal tidbit you got to walk away with is that state law on land leasing serves as a backstop for when farm tenants and landlords don't come up with their own. If we're looking for resilience, if we're wondering how to really help the farmer ranch business sustain over the long term, we are focusing on having thorough discussions with landlords and tenants about the particulars of their arrangement. And of course, this isn't just farmer as tenant who's leasing land from a non-operator landowner. This is also your operator landowner who's leasing some portion of his or her land to another producer, which is extremely common. So farmers and ranchers play both sides of this coin, and it's important for both of the parties to recognize their power and their ability to have the agreement that they want. All right. So in Sam's case, he's going to have to go with the state default rules, which are not written for garlic. Of course, now Sam may have options for recovering something, probably just money, probably not the actual land, probably not the actual garlic, but he may have options to recover some money if he talks with an attorney about the particulars. But that's part of the problem. All of Sam's money is in the ground. He doesn't really have the time and the money to talk with an attorney, but it's really his only option at this point, because he is going to have to dig into state law and figure out how it's going to affect his garlic crop. That time and money is a waste. It's time and money he did not have to spend. if he would have had a chance to think this through beforehand and come up with something that worked for him. Then even if the landlord violated the lease and tried to issue a non-renewal where the landowner didn't have the right to do that, it would be much easier for Sam to assert his rights in court because he would know exactly what should have happened and what did happen and be able possibly even to defend himself. All right, so let's get into a little bit more detail about how state law does work, because too often folks aren't figuring this out ahead of time, so we should still talk about it. So let's say that Sam is in Montana. In Montana, Sam needs to be given 1 month of notice that a lease that has historically renewed in the past will not be renewed this time for another year. So what that means is that Sam's landlord needs to tell him 1 month before the end date of the lease that it is not going to be renewed. The next question is, when's the end date of the lease? If he needs 1 month of notice before the end date, when's that? Naturally, the end date is about 1 year before or after the lease began. Then the next question is, when does the lease begin? That can be challenging. So if you ask Sam, Sam might say, well, I originally started talking with a landowner in November 4 years ago. He agreed to lease me the land then, but I didn't actually go onto the property until February when I was started to monitor the soil moisture. Well, I didn't break ground until April, and I didn't give him any rent until July, because that's when we started discussing rental rates and when, it really became relevant. So when does the lease begin? I don't know. I don't know. Sam doesn't know. Nobody knows. We're just going to go to court and argue about it. So even when you know the state laws, there is so much that is still uncertain. I think I've probably convinced you thus far that knowing state laws is not a really solid solution, is not a path to resiliency. That does not make us more resilient. Preventing issues from ever happening is what makes us more resilient. We need to focus on, how do we not become Sam? How do we not get in that situation? We don't get in that situation when we talk, when we have a lot of really thorough conversations about what the expectations are between us and what our obligations are to each other. So specifically, let's go through a list. Who, where, when, who's leasing this land, who is the lessor, what land, when does it begin, when does it end? Are there limitations on the premises use? Can we do on-farm sales, agritourism, camping? Are certain agricultural operations disallowed? We often see this in terms of animal or non-animal, and even if there's animal, can we slaughter on the property? Do we have access to infrastructure, electricity, trash storage, irrigation, all that stuff? If we can slaughter, well, where do we bury the guts? How do we dispose of them? What if essential facilities like irrigation are reduced, or critical infrastructure is damaged, like a well pump? Who fixes or restores those things? What time frame must those fixes or restorations occur within? And what happens if that still doesn't happen? Can improvements be made, particularly by the producer? Can they make building repairs, put up or repair fences, put up or repair hoop houses? And if so, who covers the costs? And who receives compensation if the relationship ends? If I, as the producer, repair a bunch of fences and I do it at my own cost and with my own labor, should I get something back at the end because I have improved the value of that land, but I got nothing from it? When does this relationship end? Can we renew it? When and how? Is a text good enough? What if I don't respond to that text or didn't receive it? Can we end this relationship early, often called termination? How do we resolve issues? Lord knows we will not come up with everything that might go wrong ahead of time. So we have to build in a system to resolve problems we didn't think about. And of course, payment terms. I put it on the end of the list sort of conspicuously. This is the thing people tend to think about right away. Well, We'll talk about payment. And there's so much more we have to talk about. And even our usual discussions about payment aren't enough. Of course, how much, but when? How should payment be made? What if it's late? And by how, I mean, can I pay partly in bacon? Does it have to be cash? Can I do it over Venmo? I'm going to go through a couple of specific scenarios, animal operations particularly. We should talk about limitations, species, breed, number of head of cattle, stocking limitations for grazed areas, gates that need to be kept closed, fences that need repair. We're going to have proof of vaccination. What about animals that get out a lot? Can you give them the boot and say, look, I'm not going to deal with that? Can we have ATVs, horses, trucks on the property? What about specialty crop operations? Particularly in Western states, we got to get worried about weeds, who's responsible for controlling them. Of course, irrigation goes without saying, whether, where, how much, when. What about water for washing? Can we use that? Soil quality or nutrient standards, packing and cleaning areas, storage facilities. What about my equipment and my implements? What about gasoline? Can I make sales, do events? And lastly, forage operations. Again, weed management and soil fertility are of particular importance. Real soon, I'm going to ask you if you, are you already talking about these things with your landlord or your tenant? Have you heard about or encountered issues like these already in your leasing relationships? Which of those things have you found to be significant in your relationships? So think about those. I'm going to ask you either to unmute yourself or comment in the chat box real soon. But before I get there, I want to say something. Now, you might have been expecting when you joined this webinar on leasing that the first thing I would say is get it in writing. Why haven't I said that yet? Why did I say talk about things? That was very purposeful. In my world, talk is not cheap. Talk is extremely important. Now, I would love for you to write it down. That would be great. But I actually see a problem develop in our agricultural community where so much priority is placed on getting something in writing that people skip over the entire step where we talk about what we want. There is an illusion in our community that there is this correct lease. It's probably on the internet and you can download it and you should just go get that and then you're good. And that is not, again, that is not where true resilience lies. Let's compare two farmers. We have farmer and rancher A. They went to the internet and downloaded a lease and signed it. So if you ask them, do you have your lease in writing? They'll say, yeah, I'm good. I got my lease in writing. Now over here, we have farmer and rancher B. They don't have a written lease. What they did is they went to the landlord slash tenant and they said, oh, I was wondering, you know, what about all these issues? Are you okay if I do that? Are you cool if I do this? How are you going to let me know if our relationship is going to continue? And they do it over coffee at the coffee shop. And they have this, you know, a series of 3-hour-long conversations, and they really get to know each other, get to know each other's needs and desires, but they don't write it down. Who do you think is actually in a better position to be resilient? I'm going to suggest it's farmer and rancher B. They have that foundation of understanding about what's going to happen on that property and what is to be expected. Now they're vulnerable to forgetting that because they didn't write it down, but they have a strong base with each other. Farmer and rancher A, on the other hand, might not even know what that lease really says because it's written in confusing language. If something bad happens or there is, you know, a delayed payment, are they really going to know what to do? Are they actually going to be in a position to resolve that issue? So I would say, to the extent that getting something in writing is a distraction and diverts us from investing in conversations and authentic agreement, It's the wrong use of our resources. It's never wrong to have a written lease, and that is really important, but let's not get distracted. So that's why I don't walk into this conversation saying, folks, we got to write it down. It is really important, and some leases that are not written down are not enforceable. So I should say that again. In some situations, if a lease is not written down, it is not enforceable. But in my situation, in my experience, most farmers and ranchers are not interested in enforcing a lease. Yes, Sam was, but most farmers and ranchers, as I like to say, would rather hate each other forever than go to court and sue each other. So we never get to the point of trying to enforce these things. Instead, this is 100% prevention and building strong relationships that can be resilient. So it's following the process of a written lease, and it is absolutely, hopefully, getting to that point. But recognizing that enforcement and that go to court step, probably not going to happen. Your turn. Are you already talking about these things with your landlord or tenant? And if you don't farm, have you heard about these issues in your community? Have you dealt with this kind of stuff? I would love to see some comments in the chat box as you have time. There are some great contributions in there from our introductions. Shannon is an apprentice with Quivera. She is an expert at preparing for tomorrow morning the night before. Another good one. We've got Valerie. Let's see, she's an expert at wooing children to fall in love with her level of spicy New Mexico chili. That's great. I don't have that expertise. Jeff from Michigan is an expert in reusing old farm buildings. I like it. I like it. And Willard is an expert at not being an expert in things and having a small knowledge of a lot of things, which is a really great way of actually being an expert. Love those introductions. Please echo whether or not you are hearing these things with your landlords and tenants. We'll read those things in a little bit as they come in. Next up, when things go wrong. I mean, as if Sam wasn't a story of things gone horribly wrong, but you know, now's when I put a little finer point on it. Okay, so our action step is have a thorough discussion with your landlord or tenant that results in consensus and write it down. Why put it in writing? Preserve memory, first and foremost. Those 3-hour-long coffee meetings are awesome, but 9 months later, we kind of tend to forget what was said. When things are in writing, it allows us to go back to what we thought happened, it allows us to go back to this neutral third party, this document that we wrote down that's going to help clarify things for us. So preserve memory. I also want to reinforce for you that the process of writing things down often helps us create clarity. When we talk about things like, hey, can I use the part of the pole barn that you're not using? Sure, yeah, use the part of the pole barn I'm not using. That sounds great, until we start to write it down and it's like, I can use the part of the pole barn you're not using. And then some bells go off in our head and you're like, that's not really clear. Which part exactly do we think they're not using? Because their perception of what they're not using might not be our perception of what they're not using. So when we write things down, that we have this inclination to try to make things more formal, and that can be really positive. That can help us point out where our blind spots are. So it preserves our memory. It helps us enhance the clarity of what we have discussed. And yes, so we can enforce it. The ability to enforce things, even if we'll never actually do it, can help us sleep better at night. It's at least a moral victory. Now, of course, bad things still do happen. And because so many of Those in our community will never go to court, don't have the time, don't have the money, don't want the damage to their reputation for doing that. Another way that we need to anticipate bad things happening is to avoid unnecessary vulnerability. We have a video on our website of a farmer telling a cautionary tale from her experience. She was promised access to a piece of land where she was going to start a dairy operation. It had great facilities, great grazing areas. She had a market for the milk. She quit her job. She bought the cows. She literally had them in the trailer, and the landowner backed out. Those things absolutely happen. And and was she going to sue the person? No, for various reasons, it was just not going to come to that. So to manage her risk, what she could have done beforehand is avoid that extensive vulnerability from the start, quitting her job and buying animals that need to be somewhere before the relationship was completely secure. So that's another good risk management strategy. And of course, when everything still does go wrong, folks need to work with an attorney to protect their ability to recover. So someone in Sam's situation really, if he wants to recover, has got to see an attorney. And when recover, I don't mean in an emotional sense, I mean if he wants money, he's got to go see an attorney. Small claims court could absolutely be available. And in many states, the threshold, if you're asking for less than 5,000 or less than 10,000, you can use the small claims court system. It can be easier to navigate, but it doesn't change the legal arguments that are going to have to be made. You still have to argue the law, that the law is on your side, even in small claims court. And that can be challenging to someone who's having to learn it for the first time. For folks in Sam's situation, what do you do if it comes time to find an attorney? Ask around for references and consider this as though you are hiring an attorney for yourself. So interview them like you would if you were hiring anyone for your business. Ask, of course, how are they going to charge you? What minute increments? 6, 15? How and when will they communicate with you? And what's their experience with farming? Do they have an understanding of the farm and ranch business? So there we go. I skipped ahead a little too fast. These bad things still happen, even though we have done everything right. So I wanted to give you a little bit more relevant examples now of what happens when we haven't come up with an agreement. So ending a year-to-year lease. I talked about Montana and I said 1 month of notice required. I wanted you to know that that is just Montana and other states are very different. Let's say we have Pat and Jamie. Pat has been leasing Jamie's farmland for 3 years now. Jamie wants to end the relationship, wants to lease to a different farmer next spring. In Oregon, we'd need 60 days of notice required, so 2 months. In Montana, 1, in California, 30 days. Now, I made some assumptions. I'd be speaking to a largely Western audience, but if any of you are more Midwest-based, it's a lot longer. We're talking 6 months in Midwestern states of notice required. Some Midwestern states have a statutory date of, November 30th, December 1, where you have to give notice for the following year. And again, you got to get back to that issue of what does 1 month of notice really mean? What are the default rules on transfer of ownership? Let's say landowner Jamie dies, goes into bankruptcy, or sells the property. Generally speaking, the lease is still going to hold. So Pat has a lease with the new landowner until the end of the lease's term, the lease year. Well, and again, we're just going through general state default rules here because, a lot of farmers don't talk about it. What if farmer Pat puts up a series of hoop houses? What now? Jamie decides, hey, you can't be on the land next year. I'm leasing to somebody else. It depends on how permanent the hoop house is. If they are considered If the hoop house is considered not permanent, then Farmer Pat can take them off the land, but only up until the expiration of the lease. So let's say Farmer Pat is given 30 days notice. He or she's got to get busy, take those things down, and haul them off before the end of the lease, if they're not permanent. Now, if those hoop houses are considered permanent, then they are landowner Jamie's. And Jamie has no legal obligation in many states to pay for the fact that there are now these beautiful permanent hoop houses on his or her property. This is not going to work for a lot of farmers. You know, these rules are a little too onerous for their situation, especially depending on the time of year in which this occurs. So folks are going to want to negotiate on these points. What does permanent mean? It's another great question. It's kind of like, when does a lease begin? What does permanent mean? We would look at a variety of factors. The use of concrete, the sinking of the footings, that's a primary one that we would consider. Let's talk about crops on the land. So let's say, much like Sam, that Pat planted garlic on October 5th and received notice of Jamie's intent not to renew the lease on October 29th. Can Pat get the garlic in July? Well, let's see. In California, crops are considered personal property. And so in California, Jamie would have to pay Pat for the garlic. What we would also really want to know is, does Jamie have to pay Pat for the value of the seed or the value of the crop in July? Because those are going to be very different. And especially if that is marketed and grown as a seed crop rather than as a culinary crop. So that's really helpful to know. It's personal property, you have a right to compensation, but the details of that are going to take some time to work out. Oregon's a little more secure. The state of Oregon says the tenant has free access to harvest crops sown by the tenant before they were given notice. So because Pat planted this on October 5th and didn't receive notice, Jamie's got to hold that crop. Now in Montana, the tenant, that would be Pat, has a right to harvest annual crops that are still growing at the end of tenancy. I consider that to be a little ambiguous. So technically garlic is an annual crop, but I don't think it's what Montana is thinking. Montana is thinking tenancy ends in the winter, in the off season, and those annual crops are going to be done. I would have to look into the case law to figure out, what does Montana really mean when they say these words? And are they going to apply it to Pat and Jamie in this way? At this point, I'm also introducing these state laws to help encourage and inspire conversation. What really is fair? Which of these are fair? Thinking about which is fair can help two individuals, farmer and landowner, start a conversation. Well, in California, it's this, but in Montana, it's this. What do we think we should do? That, I think, is a real utility of understanding state law, not so that we can become subject to it, but so that we can use it to become creative and think for ourselves about what we want. All right, let's say the well pump breaks. Is Jamie obligated to fix it so that Pat can continue producing his or her crop or livestock? Okay, are they in Montana? Now, in this case, a commercial landlord is obligated to fix dilapidation, but not to make repairs. Oh boy. So we got to ask ourselves, why did the well pump break? Was it dilapidated, or is this a mere repair? In Oregon, well, generally speaking, no obligation to make repairs. Same in California. We don't get that distinction between, is this dilapidated or just a repair? So for the most part, if Pat wants to harvest or wants to feed his animals or water his crop, he's got to get out there and, well, fix that well pump. All right, so that's a bunch of stuff. And I want to know what you're thinking right now. Let's say this happens. We got Pat and Jamie. It's the middle of the season. The well pump breaks. Pat can't irrigate. Pat asks Jamie to fix it. Jamie says, oh, next week, I promise. Jamie doesn't do it. 2 weeks go by. Pat asks if he can fix it himself. Jamie says, no, you don't know anything about fixing well pumps. It's my equipment. I'm going to have a professional do it. Pat says, well, I don't know any professionals who are available. I need this now. And Jamie says, well, call my cousin. Pat says, your cousin is too expensive. You can't get it done. And so at the end of the day, Pat does it himself and sends Jamie the bill for parts, but not for his time. So like I say here, Jamie's mad, Pat's mad, everybody's mad. How would you propose Jamie and Pat could fix things, could have avoided this problem if they could go back in time? What do you think two people should do if the well pump breaks? Now, y'all haven't been very talkative in the chat box, so no problem if you are not in a position to actually comment in the chat box, but if you are, I would love your thoughts on what they should actually do. And I raise this in some ways because I don't want to pretend that it's easy. I know it's actually very hard. It is very hard to think these things through. It's very hard to have these conversations, especially when you keep going further and further down these rabbit holes. It's easy to say, look, I'll fix it. But it doesn't happen. What if it doesn't happen? Again, we're increasing our resiliency when we can dig deeper and deeper, when we can think things through. It would be good if Jamie could acknowledge, well, I am kind of the kind of guy that doesn't always get to it right away. I always think I will, and then I don't. So you're right. I probably should give Pat an out. I should give Pat a way to still meet his needs. But that's really hard. It's hard for people to recognize that they are, insufficient in that way, or that they have weaknesses. So I want to be sure that I'm, recognizing that this stuff is not easy. That's also where I want to point at our farmer advocates in the room. This is a role where we are needed. It's a lot to ask farmers and ranchers themselves to come up with all of this stuff. And to the extent that we can support these conversations, that we can help folks be in a position to think these things through and come up with creative answers, we are providing tremendous value.
Rachel, can I ask a clarifying question about the situation?
Mm-hmm.
So why was Pat worried about how expensive the cousin was going to be to fix it? Because isn't it Jamie's responsibility to ensure that the pump continues to work and Jamie's going to fit the bill? Is this just like an example of like Pat is a frugal person and is like, why would you want to pay that much? I can do it myself.
Exactly. Because dare I say, farmers and ranchers don't like to spend a lot of money on professionals. And so it's a situation we see where, landowners don't want the farmer to fix stuff if they're non-operator landowners, because they think that they'll do, a cheap job, or they won't use the right materials. But then the farmer's like, okay, so now we have to wait for somebody who is, who's going to take too long and is going to wait for, parts to come in from who knows where. There can end up actually being a lot of conflict around who is qualified to do this work and whether someone who costs more is better or somebody who costs more is worse.
I imagine there's also sometimes a dynamic too of wanting to be a sort of ideal tenant of, I can save you money and I'll just fix it myself.
Exactly.
Or like if I complain too much, you're going to kick me out when our lease ends.
Exactly. And then when the landowner considers that repair insufficient and they feel that has caused other things to break, then they're mad. And then the farmer or rancher feels disrespected. Like, look, I did all that for you. I didn't even charge you for my time. and you're mad at me for doing that, it's things really snowball. And the greatest problem is resentment. It is the resentment that festers in the community, and which a lot of times we can't afford. We're all friends and neighbors. So yeah, there's I tried to snowball this into a bunch of different directions that all the things are going wrong. And part of what I'm getting at too is if we're thinking about a thorough solution, and we're thinking of, we've gotten to the point where we say, a qualified individual must make these repairs. A qualified individual is someone who runs a business making these repairs. In order to ensure that the quote from the qualified individual is reasonable, we're going to get 3 quotes, and then we will take the middle one. Like, all these different things that we can say we'll do to prevent problems. I see in the chat box, Shannon is bringing up that if they have invested in the relationship, they have a better chance of being able to figure it out. And if they've talked about it before it happens, they've made a plan, and so they've built rapport. Absolutely. Absolutely. And this is where it comes down to those 3-hour-long coffee meetings as being so valuable for our resiliency. If we think two women, a farmer and a landowner, are sitting down to coffee, and they're actually going to be like, well, I think your professional is going to be too expensive, and I don't think you're going to repair the well pump in time. No, we're talking about how much we understand and value each other. We're building a relationship based on mutual respect, so that when the time comes and one woman says, oh, the well pump broke, and it's really important to me that it be fixed because I really need to irrigate, that there's a fundamental level of respect. There's a rapport where we can talk about that issue honestly. Shannon also says the cause of the well pump breaking seems important. Was it someone's fault? Absolutely. And that is a common way that people will try to govern who's responsible for if something breaks. But in order to do that, we often have to be able to name what is like a normal use scenario for this well pump. What's normal use that it was designed to sustain? And sometimes we don't know that. And did we use it accordingly with normal use? Or is somebody going to say, you've been irrigating twice as much as anyone has ever done before? That's not normal use. So part of what we're getting at here is exactly Shannon's point. You can't always think of all the things. Focusing on a relationship and focusing on dispute resolution are really good ways out. I recommend that every lease have a dispute resolution clause, and not your typical will arbitration or mediation. That stuff costs money, and you're hiring somebody that you don't know from Adam to talk about your well pump. Some of the most successful dispute resolution strategies that I see are grounded in that community. Pat and Jamie agree that if they disagree on something, they are going to appoint a team of 3 individuals from within their community, like an extension agent, a crop advisor, colleagues, people they trust. And they're going to go to that body, that group of people, and explain what happened and ask them for their opinion on how to resolve it. Those things that are really grounded in community can actually be more successful over time than your typical, we'll pay an arbitrator who costs $200 an hour.
And Rachel, this is just making me think of in the new agrarian program. I mean, we're I think probably even more invested, and the people we work with, our mentors and apprentices, are more invested than your average person out there in sort of maintaining relationships and maintaining community. But when conflicts come up between our mentors and apprentices and their employment agreement, we ask them to work with us first to try to come to a resolution. And I think it's both, it's a really good skill building to try to work with someone first, to try to work through a conflict before doing something drastic. And I think in the long run really helps people out a lot by maintaining that relationship rather than letting something get super escalated.
Right.
That with conversation can be worked through.
Right. Right. Exactly. I mean, this in an ideal sense, why are we in agriculture? Why are we doing this? Why are we focused on regenerative and restorative agriculture? It's because of community. It's because we believe in what we're doing. And it's this kind of stuff that really hurts over time. If we can build these stronger relationships, we're just in so much better of a position. Okay. So this has been a really good discussion. I really appreciate y'all's input on it. Those are my absolute fundamentals. The importance of relationships, the importance of being proactive, of investing in conversation. That's the good stuff. But, because this is a, law-related presentation, I do have a couple of little legal tidbits for you that folks sometimes appreciate learning. I call it, let's indulge the attorney. What is a lease, legally speaking? So a lease is the right to use land that is owned by someone else. The emphasis there is on the word right. There is a right to own that land, and that is really what defines a lease. This is distinguished from a couple of other scenarios that might be occurring. Let's say someone has permission to use land owned by someone else. That is not a lease. That is a license. A right is something that, well, let me clarify by saying what permission is. Permission can be revoked. Legally speaking, if I give you permission, that means right now I feel like you can. Tomorrow I might feel like you can't, and I will tell you tomorrow that you can't. It's permission. It's cheap, basically. A right is not cheap. It cannot simply, I can't just change my mind. If I gave you a right, I gave you a right, and you can defend that. So permission is more like if I have a piece of land and someone asks to hunt on it, and I say, yeah, I'm not hunting this weekend. You go right ahead. Oh, it's you and you have one dog and your nephew. Okay, cool. That's fine too. Now, if then I can revoke that next weekend and I can say, look, my mom is in town and we're gonna go hunting. Then they can't. I change my mind. If I gave them a hunting lease, then I have to respect that first and foremost. I can't just call them up and be like, oh, my mom is in town, now I'm hunting, unless the nature of that right reserves for myself the ability to call them and say, nope, it's my turn. So a lease is much stronger than a license. Usually we have one or the other. If somebody is on land that they do not own, it's generally either a lease or a license. Our third option is trespassing, and that is they don't have a right and they don't have permission, so they're trespassing. I say this to reinforce our point that the right to use someone else's land can be verbal or in writing. A lease is not a piece of paper. It is a right. The right to use someone else's land can be for one day or 1 century. A year is conventional, but there's nothing about a lease that means it's for a year. A lease can be for $1 or $1 million. Again, there's nothing about that right that implies that carries with it, a value in and of itself. A lease can be whatever you want it to be, especially when we are talking about two commercial business parties, someone who runs a business, someone who leases their land. A lot of folks say, well, what about a crop share lease or a this and that lease? Insert some term here. Those are not legal terms. The law does not say, well, this is a crop share lease and here's how we do it. Here's how you do a crop share lease. A crop share lease is just a term that's evolved over time within the community to describe a relationship. But it's nothing more than what the people who have that lease want. Like, you can tell the attorney, I want a crop share lease. And they're gonna say, well, what do you want? Well, a crop share lease. No, you describe what you want. You tell them what that means to you, because you can have the world you want if you just figure out what it is. So it's really about creativity. It is not about the law. The law just stays out of it. It stays out of the details of what that lease is going to be beyond a right. The contours and nature of that right are defined entirely by us. So I have some material I'm going to give you here in the next few slides that's to help prompt creativity about how we might structure these leases. I've gone through all this setup because I get the question a lot of times. What should I pay for this lease? What's a fair rental rate? What should I do for a crop share lease? And I say, oh, what do you want? So let's think creatively. Generally, folks are going to pay for their lease in 3 different ways: fixed cash rate, flexible cash rate, or crop share arrangement. Under a fixed cash rate, this sounds something like $224 per acre, a precise amount based on usually an acre, but it could be some other metric as well. This fixed cash relationship tends to work for landowners that need steady, predictable income. It also works for those that want to avoid self-employment income and don't have any agricultural experience or knowledge. It tends to work well for producers that want that predictable expense and don't want any involvement from the landowner. And only the two involved know which one they are. Now, flexible cash rate works a little bit differently. So, X amount of the producer's gross revenue plus an addition per unit of production. So 45 cents per pound of gain. So work for that, this can work for crop or livestock producers. Now, this works better for landowners that want to broaden profit mechanisms for their producer. They are concerned about making sure that their producer, has, some incentive to make more money because they're going to keep more. They want to accommodate fluctuation in rental rates, or can accommodate fluctuation in rental rates. Like they're not like, trying to make their mortgage every month, and so it's really firm. This also works where they want the producer to pursue production techniques that may increase expenses or decrease yield. If they're saying, I want you to manage the land in this way, and that may have an impact on your yield, then the landowner should consider a flexible cash rate so as to compensate the producer for that. Hey, we're going to try this new, this new grazing technique, but don't worry, you're not going to be on the hook if it doesn't work out. I'll take less rent in this way. The converse, though, is that the producers oftentimes have to track and share the data on expenses and yields. Not everybody wants to do that. And you have to have a level of trust that the producer is going to share accurate numbers for things like expenses and yield, if those are tied into the calculation. We also have what's often called a share rate. Landowner and producer split expenses and split revenues. This really becomes a factor when the landowner wants self-employment income. And they're usually doing that because they want to build their Social Security income base. Sometimes they want to manage the timing of income or depreciate certain capital investments. These are usually folks that have been producers for a long time and are now retiring. And this is a way that they bring on the next generation or transition into their retirement while managing a bunch of financial factors for themselves. So that's an overview. There's no single correct answer for any piece of land or type of production. It's all just based on what folks want to get out of it and what their individual factors are. I have some ideas for you on how to set cash-based rates, because that's what a lot of folks end up doing. I have a few ideas. So first, of course, there's your typical market rate. Sounds easy. Finding market rates can be a little challenging, and a lot of people turn to the National Ag Statistics Service data. You can look these up. Any county in the country, irrigated versus non-irrigated acres, these are your standards. Of course, you can also ask around, because the National Ag Statistics Service data is a generalization. So you can always ask around to see what other folks are paying. It can be a little sensitive sometimes. You might not want to. You can also try farm radio, listen, see what conversations are happening to figure out what is a market cash rate. But let's think creatively. You got a lot of options for how you're going to set a cash rate. What about landowners' cost? Here's an interesting way to determine a cash rate, and it has a core assumption with it. The core assumption, the premise here, is that the landowner should make a profit from ownership that is comparable to what they might receive had they invested the money elsewhere. So land is an investment, and that we're seeking the landowner deserves a return on that investment. So again, you can go through this formula. Here's their taxes and what's a reasonable return rate. 4%. That's what folks often use. And so then, hey, there we go. That's our annual rental rate. Well, to a lot of folks, this is a bad assumption. This is a poor assumption. We shouldn't have a premise that the landowner should make a profit comparable to had they invested the money elsewhere. Maybe they should go invest the money elsewhere. Maybe what's right and proper is that the operator should pay what the capacity of the land and the market for the product can support. How about that? Then we start doing some research on what is the profit potential. So if we're talking a small scale vegetable farmer, their average profit per acre is maybe something around $6,000 per acre. Net is maybe 20% of that. Then if we take that and we subtract the cost of their own labor at a rate like $15 an hour, well, you can tell I set this up to have the farmer losing money, because that's often what happens, especially with small scale vegetable farming in the first few years. So if we're talking looking at a cash rate basis on the operator's cost, we could be looking at zero rent. That might not fly, but it might. This might be perfectly reasonable between a landowner who's really committed to seeing this farmer succeed and a farmer that knows they've got a business plan where they're going to become profitable. Not now, not yet, but it will happen. And if they can get stable tenure on this land, then that path forward is clear for both of them. So to take that same example, if we're talking about a mature vegetable farm, then we can gross a lot more per acre. We're going to net more of that. We're going to increase the cost of the farmer's own labor, but we'll still come out at actually what is a pretty high amount available from which to take our rental payment. And at this point, we'd be thinking, okay, let's of course, we're not going to charge rent of $100,000 a year. We're going to subtract for what the individual is going to invest in their business, what they're going to do to, make continual capital investments. This is a very brief overview. I highly recommend the Rancher's Agricultural Leasing Handbook, Grazing, Hunting, and Livestock Leases. It's produced out by an extension agent out of Oklahoma. They do a great job with agricultural law and leasing materials. So give that a Google. My goal is to leave 15 minutes for questions. I have 5 minutes left, and I have about 5 minutes left worth of material for you. I want to bring in the sustainability perspective. There are a lot of different practices that are going to increase the sustainability of agricultural production on that land. It sometimes goes without saying, but we're going to say it anyways. Sustainability practices come with increased costs or reduced yield, at least in the short term. Someone needs to bear those costs. Who should it be? Is it the landowner? Is it the producer? Or some combination of that? Usually it's the third. It's some combination of that. And for each of these, we need to discuss, well, for what are the relevant sustainability practices? What are the costs and the yield reduction? And how can we make it work? Going back to things like the operator's cost can help us discover, well, what is fair? How much money is the operator even making? Where is the future potential for them to make money if these sustainability practices are implemented and are successful? If we can be honest about what's the landowner's expectation for return year over year on this investment, when we can talk about those things, we can talk about sustainability. We can talk about what's fair. Usually, though, people come to an attorney and say, what's fair? And I end up saying, what are your needs? What are your resources? Long-term leases can help balance this out, because if the producer needs to suffer increased costs or reduce yield in the short term, there is the promise that that can be made up over the long term. But where we're not willing to give someone a 30 or 50-year lease, or the producer doesn't know that they want to be there for that long, we're just going to have to alleviate the costs of sustainability, doing reimbursing, doing cost sharing costs, and of course sharing the downside risks of reduced yield and things like that. All right. Where was that joy? Do not we say that there would be some joy? We did, but it's hard to find in my presentation so far. If someone is going to take my advice, then they've got some hard, awkward, and frustrating conversations ahead of them, whether they're a landowner or a producer. Talking about this stuff is hard. This is about money, values, whether or not we're good farmers or good landowners. It can be really hard to get into this and to take these steps. I'm here to tell you that it will be worth it. I'm going to give you two scenarios. You can be the ostrich with your head in the sand, who's feeling anxious, who's not sleeping at night, who is constantly looking over your shoulder, hoping something goes away. Or you can be the nice, happy baby in a swing who is free. They're free because they don't have their head in the sand and they're not avoiding something. The albatross is off their back and they can move through the world with some more joy again. When we have hard conversations, it might be hard, but we do end up where the baby is. We end up with the happiness of having done something hard and having broken through something that was holding us back. It's big. It's big to do these things. It is big to have these hard conversations. You're making it easier on yourself and easier on all of the landowners and producers that come after you. You are creating a culture shift where it is acceptable to talk about these things. You're finding solutions that other people will hear about and be able to replicate in their own communities. It's no small thing to have a powerful conversation. So think about what's right for you in your situation. Is there a conversation you need to have? How can you prepare for it? What research might you need to do? What meditating? What kind of coffee? Bake some treats? That is the work. That is part of the work of a good lease and a good relationship that creates for resilient land use. So thank you. Thank you for having this conversation with us and for contributing. And right on time, we got 15 minutes left for any questions or thoughts you want to share.
Yeah, I've got a question. So just thinking about the thought experiment you had posited earlier about the well, I could see working backwards and figuring out a lot of the language of who's in charge of doing what, but how do you really address that timing issue? So we don't do a lot of this land leasing, but with easement stuff we do, a lot of times the timing can be really frustrating for landowners wanting to get something moving, this week, this month or whatever, and doing approvals and stuff. Or getting those 3 bids can be really time consuming when you've got crops drying on the field now.
Right, right. Um, no, that's a great question. I can brainstorm with you, but I think what we need to recognize as a community is that there is no answer, and that question is the work. What we need to do is create a creative space for people to come together and think about that stuff proactively. We are doing a little bit of a head in the sand. This is really hard, because it is really hard. But we could totally set aside some time, like as an institution, when you're thinking about those lease renewals coming around, to just convene a 3-hour session where you buy a lot of pizza, and throw these things out and give people a little bit of working group time. People who don't have any stake in it, especially, extension agents and, crop advisors of those types, and say, hey, what would you do? Literally, we've got Pat and Jamie. What would you do? And make them do it. You could even maybe write a grant to fund it, and then talk about what they said they would do. Those are the conversation that is the work, and it is really challenging to make it happen. But yeah, I would say the work isn't even between you and the people using the property. It is a broader community level conversation to have. Usually those of us on the inside, we can't see the forest for all the trees. We're like, well, I know that person isn't going to like it. And so we shut off from those kinds of solutions. And we also let it go until it's really pressing. So we have to build ways to get around that, which is a really good way of me not answering your question, because I don't know. And honestly, I love doing in-person workshops, because I will, stupid pandemic, I just needed to end. I put people in groups and I'm like, you'll get me an answer. I'm waiting because I find it so interesting to see what people can actually come up with.
Oh, and I think you're spot on with the continued conversation. So, slightly different scenarios, but we have, policies that we work on with our board and put in place and things, but pulling those up and dusting them off at the last minute when things come up is a lot different than communicating those things with your landowners, with your lessees or whatnot. So for sure.
Yeah, Tony.
Yeah. Can you speak to the concept of like a rolling lease? So say you have a 2-year rolling lease, and you always know you have 2 years ahead of you, basically, to from the term date.
Right.
Are those very common? Your experience with them? Any downsides to them?
I don't see them a lot. I do have a bit of a Midwestern, well, a lot of a Midwestern bias in terms of what folks are actually doing. And year to year is, of course, the standard in these parts. But where we do see things become longer, that is the form they tend to take. Is it really pushing it, 3 or 4 year rolling lease? And it's a great mechanism as long as everybody understands exactly when that notice could be issued and what the ramifications are. But 2 years is perfect. We avoid things like those garlic situations, perennials, other investments being made.
Thanks.
Well, I think, okay, great. I was just gonna say, I saw you talking, but you were muted.
Sorry. Yeah, screwed up there. So maybe to follow up on that a little bit. So theoretically, say I have a 1-year lease that expires on December 1st, and I'm supposed to get a 1-month notice if they're not going to renew, but come November 15th, I haven't heard anything. Do I assume that I have another year or to renew, or can the landowner come in and say, I'm going to terminate the lease, you've got 30 days from November 15th. So as of December 15th, you're out. I mean, can that be
Yeah.
canceled like that? Or how,
Excellent.
or
Right.
once you get into your 1 month notification period and haven't heard anything, do you assume you have another year?
Well, technically, you can assume you have another year, but if push comes to shove, the person who's going to be standing on the top of the pile is the landowner. When
Okay.
push comes to shove, if the landowner fails in their duty to issue adequate notice and still wants to force the landowner off, they usually can. They just have to, I'm sorry, if the landowner wants to force the tenant off,
Yeah.
they usually can. The court will back them up and they will award monetary compensation to the farmer for their losses. They will not force the landowner to keep the farmer there. So that's oh, I'm blanking on the name, but it's a kind of relief that you can ask for the court. Ask, you could say, no, you let me stay here. And the court's gonna, in almost all circumstances, say, no, you can't stay. Here is $10,000, leave.
Okay. Thank you.
So yeah, this is a tough game to play. Between mid-November and December 1, what's a farmer or rancher really supposed to do? If you ask, you might get a no, and then you feel really bad, you didn't want to leave. And maybe if you wouldn't have said anything, but if December 1 passes, and are you really in the clear? You're still not in the clear. You still have that anxiety because you can still be kicked off. But of course, that could also happen in June. And it does happen where, landowners come in a bluster, usually because they sold, they, literally sold, and they told the buyer that they would terminate that lease and that person would be gone. We see that all too often. And so then they're in a real bluster to try to get this producer off now.
Right. Right. Okay. Thank you.
Rachel, I know on the call yesterday, you had a document that you wanted to share in the chat. Do you have anything like that today, or is that just for yesterday's call?
I did not this
Cool.
time.
Just wanted to make sure.
Yeah. Sorry, I was just checking my files. Is there something I was going to hand out? No. But I would be happy to send along a PDF copy of the slides if anyone wants to take a look at things for future reference. And I see Shannon asks in the comment box, things are changing in the West around water use and irrigation. Are there least considerations you're aware of for that? Nothing specific besides a lot of discussion about what is expected for this land, but too often it's not actually the landowner that has real control over whether or not sufficient quantities of water are delivered and with the equipment to secure them. Sometimes those factors are out of the landowner's control as well, and all of the pledges in the lease to secure that don't end up coming through with water for the individual because the reservoirs are too low or things like that, or their rights get bumped. So you're right, things are changing, and that change is not good for the resiliency of the producer. And I think we're in a place where we are trying to find new strategies, where we're trying to reorient ourselves to what the world is going to look like with less water. And we don't have a lot of good solutions right now. And by the world with less water, I mean the American West. We're doing fine with water out here for the most part. Some of us have too much. I'm going to print my my PDF handouts real quick here, and I will drop them in the chat box. So just a second on that. It's a little bit large. I was going to try to reduce the file size here if for those that need to download something smaller. So one more second and I'll have that for you. All right. Have the file size option there for you.
Okay, well, thank you so much, Rachel, for presenting today and yesterday. So yeah, just another plug. There's a great recording of the workshop that Rachel did yesterday on finding the right business structure. And like all other workshops, the recording from today will go out. So if you want to go back to anything, that will be available in the end of day email.
Good to be with you all. I appreciate it. Keep Farm Commons in mind as legal issues, business law issues of all types come up. We love speaking to producer groups and also nonprofit agriculture extension professionals to help folks get farmers in a better place with their legal resilience.
All right, well, thank you again. And yeah, hope everyone, if you're going to the conference next week in person, looking forward to seeing you there.
All right. Bye, everyone.
Bye-bye.